reject your patent or can be invalidated later. And then you asked about priority. There are a couple of big patent treaties in the world by which if you have a priority date, by the way, that is the date that you first claim the invention, okay? And there are treaties in the world by virtue of which if you file a patent in one country, all the other countries that have signed that treaty will have to honor that priority date. And so basically, if you file it in one place, assuming excuse me, that they belong to that treaty, it will be honored everywhere. Okay, I'm going to go on here. Oh, yes.
I'm sorry, the second half of my question was about the monetary risk, or what's the principle there?
Okay, so money damages for patent infringement, in the U.S. it's different from other places. In the U.S., and I think almost everywhere else, the basic measure of damages would be a reasonable royalty. So if, say, I have a patent and I license it at $1 per unit to most people, and then you infringe, then the basic measure is going to be $1 per unit. But in the United States, actually, there are possibly much higher damages because if you're found to have knowingly infringed the patent, I can ask for up to 3 times as much. And I can also ask for attorney's fees, which could be the average patent lawsuit in the United States from beginning all the way, if it goes all the way through arguing before a court, $2 million in fees. So it's potentially a lot of money. And that's why I said the amount of money from patent litigation in the United States, it just dwarfs the rest of the world. Because we have really, really strong monetary relief in the United States. It's not that way in other countries, and also just the amount of legal fees would be less in other countries. Okay, software patents. This is an area of great controversy, so I just wanted to talk about it for a moment. Because some of you may have heard people say, software patents are terrible, and I just want to explain what the controversy is so you can come up with your own ideas about it. First of all, there's this idea about patents that you can infringe them without knowing. And this is true not only for software patents, but any kind of patent. That if you sell a product and it happens to represent an invention someone has a patent on, it doesn't matter whether you knew about it, because remember that I said that a patent, it lays open the invention for the world. So you actually are charged with knowing that there's a patent, even though you might not have really looked, right? And so you can actually infringe patents without knowing it. And this is something that people point out as a problem with the patent system, but this is simply the nature of patents. If you hear people complaining about software patents, this is actually one of the main things that they complain about, but it's important to understand that that's not just true of software patents, it's true of anything. If you come up with a new drug, and it happens to infringe the patent of someone else, then they might be able to sue you, even if you didn't steal it from them. So this is the nature of the patent system. The other thing that people say about software patents is that you can protect software via copyright, so we don't need patents for software. And I think this is a pretty legitimate argument. But then if you're going to talk about policy, I think you need to ask, what makes more sense to protect software? Patents or copyright? Patents. The reason, I think there's an argument that patents are better, but that's not a very popular argument. But I'll explain to you what the argument is so that you can decide. One of the reasons there are software patents in the United States is when the courts were presented with software patents, here's what they said. We can't really tell the difference between a software patent and a hardware patent. And the reason we can't tell is that software does the same thing hardware does, because it's changed so much over time. Yes? Are we running out of time? Okay. The other is that people who are involved in development of open source and free and open source software are very concerned about this issue. And the reason they're concerned is that they're giving the software a way to the world. They're making it available to everyone. And if they were responsible for patent infringement, then this gift that they're giving to the world, they could be required either not to do it by injunction, or they could be liable for a lot of damages, and they don't think that's fair. Also, another problem is that software patents were not very common in the United States before about 1990, because people thought maybe software wasn't patentable. But when the court said software was patentable, the courts had not spent a lot of time looking at software patents. But software had been around for 20, 30 years before that. And so when you apply for a patent, you know, the examiner looks at it, and one of the things that they primarily look at is what patents have been filed in the past. And so as you might be able to tell from what I just said, there were not patents filed in the past, and so, in fact, people were getting patents on things that were not novel. And so this was an issue about patent quality. In other words, the patents weren't issuing properly. And so that is what I mean by the lack of patent prior art. One of the things people have done to address this, particularly in the open source world, is they've developed these places where people can put prior art for patents, because they don't want software patents to issue. So what they do is they make a bunch of software available for the patent examiners to look at. And so the patent examiners, they don't just have to look at the patent prior art, they can look at other prior art that was in the world before that time, so that they will issue less patents. Finally, this is considered a battle of the IT sector versus the biotech sector, because pharmaceutical companies love patents, and software companies and IT companies don't like them very much. The reason pharmaceutical companies like them is that that's pretty much the only way they can protect their products. And with software, it's you know, there's alternate copyright protection, and also it's just thought that there are other ways in the business model to protect against stealing of inventions. But with biotech, it's very easy to reverse engineer the products, and so that's one of the only means of protection. I think I'll probably skip that, but and that's probably enough for now. But does anybody else have any questions? Yes.
I have two questions, one about open source and one about the biotechs you just mentioned.
Mm-hmm.
Is there any legal way to actually enforce the law on those tech companies? Because there's been recently quite a controversy about whether or not Microsoft has been implementing open source, basically parts of the Linux kernel within their own kernel.
Mm-hmm.
And you couldn't really tell whether or not that is true, because you just can't look into their code. But
Yes.
they nonetheless went to court. And my
I'll answer that one first, and then we'll go to your second question, because otherwise I can't remember a question for more than 5 seconds. It's my own problem. If Microsoft were using open source software in its operating system, yes, there would definitely be a way to sue them, and Microsoft would be very, very concerned about doing that. In the United States and most places elsewhere, that's a copyright infringement claim, and it's perfectly legitimate to make it against Microsoft. Now, they would fight it, and they might, for instance, say that the kinds of arguments they might use would be, yes, we use this piece of software, but it's not really copyrightable, because, so those of you who here has ever written any software? Do we have a few people? Okay. So the way you write software is very functional, and copyright protects expression. So if I want a piece of software to do something 100 times, it's very easy to do, but there's only a few ways to do it. Okay. So just writing what we call a loop to do something 100 times, that's not protectable by copyright, because it's not really expression. It must be done that way. The copyright protection for software is it's very hard to apply copyright to software.